This is a current case brief on the case Mistich v. Value Village Stores, Inc. The citation is Mistich v. Value Village Stores, Inc., 2016, HR TO 1229. Facts. The applicant who worked at Value Village injured herself at work and asked for a less physical section to work in and requested fewer work hours. The applicant could only work certain hours as she had a family responsibility of taking care of her elderly mother every afternoon and weekends. She found that her workplace, Value Village, did not help cooperate with finding a new time that worked for her. The applicant reports discrimination in the workplace based on her family status. Facts. The applicant reported discrimination at work based on her devotion to her family responsibility. Since the applicant was injured, she had to change the section she worked in as it required too much heavy lifting and required less work hours. This meant she needed a completely new change of schedule. Unfortunately, she could only work a specific time as she took care of her mother in the evenings and weekends. The store manager at Value Village had trouble creating a new schedule based on these required times. In the meantime, the applicant is failing to come to work at all. Facts. The store manager wanted a reason why the applicant wasn't coming to work, which she then explained how she was taking care of her mother. The store manager stated that he needed evidence that she could not attend work because her mother was ill and needed constant help from the applicant. The applicant then gave a brief doctor's note on how her mother needed some help, but the note did not help prove the absence of the applicant from work for the last month. Finally, the store manager had to declare the applicant unemployed from Value Village for her absence from work. There are two issues present in this case. The first is the applicant's absence from work measured as a reasonable excuse because of her family responsibility. And the second is the termination of the applicant's employment considered discrimination based off of her injury and devotion to helping a family member. The decision from the tribunal was that the appeal should be dismissed. Rationale. The applicant had a very strict perspective on how her human rights defended the fact that she did not need to provide medical information to prove that she could not work. Unfortunately, this is not valid. The tribunal found that the applicant was required to provide sufficient information to support her family responsibilities. Because she failed to provide this information, the store manager had every right to let her go as an employee since she was refusing to come to work. The first issue states that the applicant did not have a valid reason to miss work and did not support her reason with enough evidence. The second issue follows, as the store manager did have the right to declare the applicant unemployed, but was it discrimination against the applicant? The Human Rights Code states that every person has a right to equal treatment with respect to employment without discrimination because of their family status. The applicant's work days did not seem to conflict with her stated hours of when she needed to help her mother on evenings and weekends. The store manager was only aware of these times when the applicant indicated that she couldn't work, and found a new schedule later on that did not conflict with those specific evenings or weekends. The applicant could have worked these shifts and still completed her family responsibilities, which is why the store manager asked for evidence on why she was missing work. When the applicant gave a brief note, the store manager had the right to let her go as an employee, not based on discrimination of her family status, but based on her lack of presence at work. Analysis. After the case was dismissed, the applicant gave more information about her family's responsibilities towards the tribunal. She stated that she was accountable for giving her mother her medications every day, feeding her as she had trouble eating and moving on her own, and was becoming very forgetful, which is why the applicant needed to be taking care of her mother more often. The tribunal states that this new information could have helped her be excused from work, but that the applicant was asked for more evidence from the store manager and denied that chance, as she thought it was to be kept in the family and wasn't the store's concern. Since the store manager was not aware of these facts, the applicant's unemployment is still valid and not seen as discrimination against her family status. Survey question. Do you think that it is fair for the store manager to declare the applicant unemployed based on a lack of medical evidence that she considered private? Please respond yes with a check mark or no with an X. Thank you.